Ena no ada eba be breaki edemamo Attorney General OCU OSP on ne prosecution and as the prosecutorial power ebusua ene High Court the final ruling ababontin OSP omo ruling against OSP ebusua enye asam keto akra and sisi ano omo order Attorney General say HSA and also Oma order OSP say on hand over all ne corruption cases to Attorney General Abusia eno na project say the ato your screen no enchen the amamono High Court strips OSP of prosecutorial powers. The court has ordered the AG to take over all prosecutorial powers. Abusia you see how the OSP asem atono sisia OSP no office na wo no akwa say office no sisia useless cause Attorney General edeni kokko mu court no sisia court no age prosecutorial powers na ama Attorney General unless say Attorney General na ebe pone and say ebetumi ama OSP power say umfa enye prosecutions entino OSP ne office no enka sisi akrampo de enka ye pamon ne free no office kra enka ye sisi an oni any power bia say say ode e prosecute obi anase oni any power say say ode e file cases against amanfo sisi ano Attorney General every ni case na abusia mama yanko na yankonko tie ensem bia eboboba efa ho unsubscribe ya subscribe na hit on the notification bell so na be any update bia be drop in one so onsa ebetumi akabi yebesremo say ye mass breaking news we a delay abusia mama yanko na yankonko tie ensem ekoso
to the phone lines right now because this has been causing quite the stir. Justice Abdullah is a law lecturer, private legal practitioner as well. Is joined us via the phone lines. Counsel, I appreciate you joining us. What meaning are you making of this latest decision by a high court, considering a matter of such nature is currently pending before the Supreme Court?
As you rightly described it, it wasn't expected, at least not within this period of history, while all the issues about corruption, the rising corruption-related matters and all of that are ongoing, and then trying to figure out means of fighting corruption, and this blow comes up at this point in time in our lives. It's very disturbing, particularly also if you relate it to the fight to bring back Ken Oferiatta, which is which the OSP is highly instrumental in that fight. Indeed, it is at the forefront of that fight, and so this completely takes away a lot from us as people, and it literally gives from the Oferiatta's camp a huge leverage over all of us, and possibly a difficulty in even bringing him back, winning the extradition case before the U.S. court. And so, but without relating it to that, I mean, coming back home, I think that it is also disturbing, particularly because the decision of the High Court almost amounts to the interpretation of the provisions in relation to the Article 88 and also the provisions establishing the OSP. And I thought that if the High Court was minded, it probably could have referred that portion of it to the Supreme Court for interpretation. That would have been ideal from where I stand, because the conduct about the decision as made by the High Court amounts to an interpretation which it does not, I mean, of which it does not have that authority to do so. There is no jurisdiction of the High Court that allows it to interpret provisions of this nature. It can apply, but definitely not to interpret it in the light that it has done at this point. Now, having said that too, you would literally agree with me that the entire setup of the OSP and its machinery, its structures are literally set up for the purposes of these. I mean, from this angle, that is the prosecutorial angle. So once you take out the prosecutorial authority from it, the entire office becomes a useless entity. And so you will not need that office to even continue in its operations. I mean, going forward, if this decision is allowed to stand, it literally takes away the foundation of the OSP, and the OSP would be useless and meaningless to exist in our books if this decision is allowed to stay. So on the basis of these, I completely support the decision of the OSP to appeal this decision, and I would strongly urge all of us to find means of supporting, I mean, particularly anti-corruption fighting institutions. Already there is a similar issue brewing up in the Supreme Court on this subject. If this decision had come from the Supreme Court, of course, we would have thrown in the towel and then said, well, maybe let's go back to the drawing board and then see how best we can come back to fight corruption from another angle, or maybe go back to our earlier advocacy, which was that has always been that it should rather be the Attorney General's office that should be decoupled from the Ministry of Justice, so that once you have those two independent independent institutions operating from that angle, one may not necessarily have to be a ministerial position, then we wouldn't have to have this kind of fight today. But today is a big blow.
The point that, look, the court in making this pronouncement lack jurisdiction, what then becomes the use of the OSP's challenge of the reasoning of the court? Because there is no authority, no basis upon which the High Court is supposed to be making a pronouncement like this. What then becomes the authority or the basis for which the OSP want to challenge this? Is it to rectify the notion currently in the media space? And also, this will not be binding on other high courts, really. And so what is the point?
Yeah, indeed, it may not be binding on other high courts, but it will be highly influential in changing and in fact in the narrative going forward. And then indeed other high courts who could be influenced by this. And so if you do not challenge it and get a firmer authority on this subject, then your continuous existence becomes shaky. And so
right.
And it is the reason you have to challenge it right away. You don't even sit for a minute on such a dangerous precedent being set. Remember, it is a high court. Other high courts may not be bound by it, but they could be influenced and they could be given decisions questioning your authority in this light. At the moment your authority is questioned, you no longer have any basis to prosecute anyone.
Absolutely. Of critical importance to a lot of people in this conversation about the prosecutorial powers of the OSP, some say that is that case pending before the Supreme Court. Now, considering that the court refused to allow the OSP be a party to the suit, where then lies the ability to provide counter-argument to the court which will matter most? Because when the Supreme Court does make pronouncement on that matter before it, irrespective of whether or not the OSP is successful in its challenge of this High Court ruling, it will matter very little, because what will be decided by the Supreme Court will then be binding. In respect that they don't have a forum there, where leaves counter-arguments in that substantive suit currently before the OSP, considering the AG sides with the plaintiff in that particular matter?
Indeed, you put it rightly. It is difficult to say that the decision of the Supreme Court will come tomorrow or the next day at this point. And so, in view of that, you cannot hold on to your horses saying that because the decision of the Supreme Court is potentially coming very soon, you will not take any decision in respect to the High Court. That would be rather a counterproductive decision to take. You have to take all steps available now until that Supreme Court decision comes. That Supreme Court decision may as well come and not even affect the prosecutorial powers of the OSP. Whether or not the OSP is allowed to even make a case before the Supreme Court. Mind you, the Supreme Court doesn't need the OSP's input necessarily to make a decision, a proper decision in favor of the continuous existence of the OSP. The Supreme Court is allowed to take opinion from everyone and anyone, including amicus. And so, whether or not the OSP being made a party or being allowed to make a position his position known before the Supreme Court will not necessarily impact the decision that would ultimately come from the Supreme Court. So that's the first thing that we need to know. The second thing that we need to know is that, as I indicated, one does not need to wait for the Supreme Court's decision to appeal the decision.
Absolutely.
The two can go on simultaneously. And if it turns out that the Supreme Court's decision adversely affects the continuous existence of the OSP and invariably reaffirms the decision as made by the High Court today, then of course any pending appeal becomes immaterial, and at that point you can then throw in the towel and then take an appropriate decision to address whatever concerns that may exist from that moment.
Help us understand just one more time this matter from the High Court. I've seen a number of reactions already, and you yourself have been corroborating the fact that the court did not have jurisdiction to have taken upon itself the matter to make the pronouncements that it has made. In the jurisprudence, the legal framework within which we work with, what, I don't want to say punishments, but what counters exist for when courts assume jurisdiction and make pronouncements which you are saying they did not have authority to make? What are remedies outside of the appeal, obviously, which you are advising the OSP to undertake?
Indeed, the OSP has two routes to remedy the situation as it exists today. The first one, the most popular, as everybody knows, is the appeal route, the easiest route to take, if you like. There's also a judicial review available to the OSP. The two can go on simultaneously. And indeed, I would strongly urge the OSP to invoke both simultaneously. And it doesn't go against the law to invoke both anyway, just for the purposes of clarity. They can invoke judicial review, questioning, and that would take the OSP straight from the High Court to the Supreme Court without having to go to the Court of Appeal. So straight you jump to the Supreme Court on a judicial review that the High Court did not have any legal basis to make the pronouncement that it did on the basis of, as we said, lack of jurisdiction. And if it is clear on the face of it, because it appears quite clear on the face of it that indeed the High Court doesn't have it. But of course, sometimes until you go into the nitty-gritty, you would never get to know of some of the pitfalls that you may encounter. However, as it stands now, as on the face of it, it does look like the High Court doesn't have jurisdiction. And also on the basis of that, they can mount a judicial review application before the Supreme Court to quash the decision of the High Court as it exists today. And if that succeeds, chances are that the Supreme Court could merge any potential application for judicial review with the
which was the point I was going to make, that could that happen, considering, or could that be another means to which the OSP now then becomes a party to that original suit which they were refused initially, if they go through this second route, this judicial review route you're making reference to?
Okay, so since I asked the question on your behalf and I'm giving the answer, I would say that yes, indeed it is available to the Supreme Court to consider both at the same time, not necessarily by merging them. They could consider both at the same time. Sometimes the Supreme Court also operates on purely prudential basis by ensuring that they do not have to replicate their resources when they could merge all and make a decision or a pronouncement that solves all problems or all cases before it. And so it is on the basis of that sometimes they could, rather than saying that, okay, you know what, let's merge these two, which sometimes could not be measurable, they could say that, okay, we are giving a decision in this because this one is right for a decision to be made. And that decision, we would assume that it also encapsulates all the matters in reference to case B, because the matters raised in both cases are germane and are the same, that we believe that the decision in case A would resolve the decision in that matter too. And in that case, when they do that, it turns out that they will dismiss the second case or the third case and refer them to this first one.
Absolutely.
I remember that happening in 2001 thereabout, when Richard Sky filed a suit. In fact, there were about 3-4 different suits, one of which was all of which literally surrounded the case of the Deputy Speaker of Parliament being allowed to vote while sitting as a Speaker of Parliament. And all
Absolutely.
Yeah, there were similar cases, about 4 or 5 of them. And one of them which was decided was Justice Addo, Attorney General. And what the Supreme Court did was that the moment they gave that decision, all the other cases were dismissed. Not because they were frivolous cases, but because they had already given their opinion, their decision in the Justice Addo Attorney General case. And so sometimes this could be the route they would take. And so they have all kinds of means of resolving such matters.
Counsel, I appreciate you greatly for speaking to us this afternoon. That's Justice Abdullah, as a private legal practitioner as well as the law lecturer, speaking to us this afternoon on the latest. We know that the Office of the Special Prosecutor has been reacting to the development. They say that the High Court does not have jurisdiction to, in effect, strike down part of the Act of Parliament as unconstitutional. They argue that it is only the Supreme Court of Ghana which can strike down parts of the Act of Parliament as unconstitutional, and that the Office of the Special Prosecutor is taking steps to quickly overturn the decision of the General Jurisdiction Court. The Office of the Special Prosecutor Act, according to them, remains valid and in force. And they provide a bit more, for those of us on screen, they provide a bit more in terms of context, that the criminal court dismissed an application by the accused person seeking to strike out the case. And so there are two separate cases, right? There's a case in which they are prosecuting an individual over some corruption-related matters currently under investigation. Now, in that particular case, from what the OSP tells us, they raise questions about the authority, the prosecutorial authority of the OSP, which was dismissed, and the court has subsequently stayed its proceedings pending the outcome of the No Adamte case currently before the Supreme Court. But the OSP says they went before the general jurisdiction of the High Court, and filed this application, which has now become the basis of this decision by the court. And most definitely something which has piqued quite the interest and will have a lot of tongues wagging in terms of the analysis. We've got the first bit of it from Justice Abdullah, who's a private legal practitioner and a law lecturer on matters of the Constitution as well, this afternoon. I've seen H. Kwesi Prempeh write about this. I've seen Oliver Baka-Vomo write about this. Professor Kweku Azar as well has put up a post in this. And they all seek to make the same argument that, look, the court went into areas where it didn't have authority to. And so, but Justice Abdullah says, yes, that's the case, but it's still in the interest of the OSP to challenge it, because then other high courts can begin, even though it's not binding on them, they can begin to look at it and say, well, if my colleague in this court says this, let me look at the argument and the reasoning, and that could be a challenge for the court, for the entity, the OSP, in other courts. And so they should challenge it whilst the Supreme Court matter continues to remain pending. But
we'll see how it plays out.
Absolutely.